Hello everyone.
Hello, ma'am.
Hi. So I was waiting for 15 minutes. I thought no one is joining, so I just ended that meeting. Just we'll wait for 2-3 minutes and then we'll start if anyone else is joining. Okay, so like a small part is remaining, right? From contract act, a small part is remaining. We will continue with that today and then we can move ahead with the other topic. So in last class, we discussed the indemnity and guarantee part we have completed, right? So next part that we have is regarding bailment. So it is chapter 9 and there are few sections that relates to bailment. So bailment is sections 148 to 171 and then again we have two different sections, 180 and 181. And in between whatever sections are there, those sections are relating to pledge. So sections 148 to 171 and then again we have two other sections 180 and 181. So what is the contract of bailment? Anyone? So contract of bailment and also the parties involved, right? All these three things are defined under section 148. So try to remember these sections, like which all sections define the specific types of contracts and also the parties involved in these contracts. So for bailment, we have two different parties, Bailor and Bailee. So bailment, Bailor, Bailee, all these three things are defined under section 148. So what is bailment? Basically, it is delivery of goods by one person to another person. So basically the owner of a certain goods or maybe a legal representative or someone like that would deliver some goods to another person. Now, why these goods are delivered? For some specific purpose. It may be to get a servicing done. It may be to repair those goods. It may be to make something by using those goods or something like that. So the person will deliver some goods that some specific purpose is to be done with the help of those goods. And once that task is done, once that thing is done, it should be again returned to the owner or the person who actually gave it. So once the work is done, it should be again returned to the person. So this definition is given under section 148. What is a contract of bailment? And also the parties involved in a contract of bailment, the bailor and bailee. So if owner of a certain car, if he gives his car for a servicing or for cleaning or like washing or something like that, then what happens, that also would be termed as a contract of bailment. The owner is basically giving his car that this like for a servicing to be done or for cleaning that car or for washing that car or something like that. So in that case also it will be what? It will be a contract of bailment under section 148. Once the servicing is done, that car should be returned to the owner. Once it is washed or something like that, it again should be returned to the owner. So once the work is being done, it should be returned to the person. Now section 148 defines what is bailment and also who all are the parties involved in such kind of a contract. So there are two parties, bailor and bailee. Bailor is the person who is delivering the goods, basically the owner of the goods. If I want to get my laptop repaired and I'm giving it to a certain shop where they would repair and get the things fixed, I will be the bailor. And the person to whom I'm giving it, that person would be the bailee. So that person needs to repair all the things that are not working in my laptop and once it is done, once everything is fixed, they should return that particular laptop to me. So Bailor and Bailee, try to remember who is a Bailor and who is a Bailee, and also it's one section only that is defining all these three words. So Bailor is whoever is delivering the goods, the owner basically, and Bailee is to whom goods are delivered. So you can also remember, like, we have a lot many specific types of contracts, right? So for that, again, we need to remember who all are the parties involved in those kind of contracts. So you can just take one example where you are also one of the parties, you know, like in that example, you are also one of the parties, and accordingly you can remember. Like you can think in case of bailment, right? You can just think that you are giving your laptop for, you know, like some kind of a some parts to be fixed, and who you are the Bailor. So like that also you can remember. You can take you yourself as an example, and then you can remember. If you are giving your laptop, you are the Bailor, and the other person would be what? Other person will be Bailee. He needs to get the work done and again deliver that particular those goods to the person. So he will again deliver that laptop to you once it is fixed and everything is done. Now there are certain duties of both Bailor and Bailee. So for the duties, right, what is important for these specific types of contracts, right? Like mostly what kind of questions are being asked is which section is defining that specific type of contract, and which section is defining the parties involved in such kind of a contract. So that part you try to remember, and also the rights and duties wherever it is mentioned, those sections are also somewhat important. Like a question might be asked based on a certain duty of a Bailor or a right of a Bailee or things like that. So here are the main duties of both the parties, both Bailor and Bailee, that we have. So we will see these as well. Okay, so first of all, duties of Bailor. Bailor is the person who is delivering his goods, right? So while delivering my goods or during that entire process, I will have certain duties that I should fulfill. So what is the first duty? Disclose faults in the goods. So what happens is, in case of bailment, it's my goods only, right? I'm using those goods for a long time, and then I want to deliver those goods. So there is a chance that I know what is working, what are the faults in that particular goods or things like that. So what I should do is that before delivering that particular goods, I should inform the other party that these are some of the faults that I have in this particular goods. So you should be careful with regard to all these things, so that the other person do not suffer any kind of, you know, like unnecessary harm or unnecessary damage. You do not have to suffer. Take for example, if I want to get like something fixed in my phone, okay, like my display is not working maybe, or the speaker is not working or something like that, I want to get this phone repaired. Now what I can tell is that this you know, like the tempered glass that I have on my phone, that is broken, so you should be a little careful with that. So what I can do is that while I give my phone for, you know, like to get it repaired or something like that, I should inform them about any faults that I know is there in my phone. Might be I can tell that, okay, fine, my speaker is not working, but sometimes, you know, like sometimes it just starts working and the volume will be very loud. So you should be very careful. If you are, you know, like testing or something like that, you make a phone call, the volume might be very high suddenly. So what I should do is that I should inform the other party about any kind of faults that may be there in my goods. Why? Because I already know that, right? So I should try to save the other person from any kind of unnecessary harm or risk or loss that the other party might you know, like suffer. So it is section 150. Is this part clear? Section 150. Section 150. Any other example that you can give where, like, I have a duty that I should inform regarding any faults that I have in my goods? Any other example that you can give? Anyone? Section 150, duty of bailor to disclose regarding false and goods bail. Is the section clear? 150? Is it clear? Vijay, Mansi?
No.
Okay. So any other
Yes,
example? Any other example that you want to give?
ma'am, can we put an example for tailor? Like we give them a cloth and it's their duty to prepare our desirable kind of dress, and then they will again give it back to us and take that amount for
Yeah,
the same.
for bailment we can give that example also. You are giving a piece, like fabric to the tailor. You want some kind of a dress to be made with using that. So for that also we can take that example. Even sometimes like we hire these cars and also like two-wheelers and all when we are visiting in some other places or something like that, like Zoom car and all of that we have. That also may be taken, that they are delivering their vehicle to us for a certain duration. What we are doing, we are using it once our purpose is over, once we have used it for the desired number of days or things like that, we will again return it to them. We are giving our clothes for ironing, washing, or anything where we are giving our goods, basically that would be included. That it's also like a bailment only. So disclose whatever like false or any defects are there in the goods. We should inform the parties regarding that. Maybe if you see, like if you try to book all these things, right, your what is that, like this rentals, bikes and all you get, right, bounce and all. And also what is that for that electric cycle? Mm, I forgot the name. Okay, so what happens is that when you try to book them, right, they will show you that, okay, fine, for this particular vehicle, only this much percentage of charge is remaining, because you need to charge them, right? So they will even show that, okay, fine, like 20% charge is remaining, and for with 20% charge, you can cover this much distance. So like that, they will inform you prior only, so that you can also decide that, okay, fine, I need to just go to a nearby shop. Maybe it's hardly like 500 meters, so I can take this vehicle and then I can go. So like that, it would apply to other cases also, where I am aware about some kind of a fault, some kind of a defect or things like that. I should inform the other party with regard to same. So if I am knowing that, okay, fine, this vehicle is having only like 20% charge left, I should inform the other party also that it is only having 20% charge, and it will help you cover this much distance only, so that it will not stop in middle of his way and then he will have to find another vehicle or things like that. So this is a duty that a bailor will have, that he will inform regarding any kind of faults that may be there. So next we have duty to indemnify. So bailor's responsibility towards the bailee. So what happens is that in case the other person suffers any kind of like loss or harm during this process, what happens is that it is duty of the bailor that he will indemnify the bailee. So during that process, if the other person goes through any kind of loss, or he need to incur any kind of expenses or anything like that, or basically some kind of a loss that the other person will suffer, the bailee will have to like it is the duty of the bailer that he will have to indemnify the bailee. So if he is delivering some kind of goods and the other person has to incur some kind of a loss because of that, so in that case it will be duty of the bailer only that he will have to like indemnify the other person with regard to that. So take for example, one person is maybe he is like delivering a certain goods to the other person, that maybe for a servicing, or I need to fix a certain part of this particular machine, you take it and you get it fixed. So during that process, what he comes to know is that he just took the machine and he went, then he came to know that it was all broken. So he had to maybe take a vehicle and then he had to take it to the center or something like that. So in that case, he can claim that, okay, fine, I had to book a vehicle and then I had to take the machine there because it was all broken and all of that. So with regard to those cases also, the person can say that you need to indemnify me. Whatever loss I have suffered, that you need to pay. So it is 164. Then also duty to pay for expenses incurred. If there are some other expenses that the other person had to incur in performance of this contract of bailment, those expenses also the person can claim from the person. So take for example, someone like for free only someone is providing a service, okay, like maybe one person wants to like publish a book and he wants someone to prepare a like cover for that particular book, someone to paint a cover for that particular book. If I am providing that service for free, if I'm telling him that, okay, fine, you know, like give your size, desired size and sample of the book, and I will prepare this cover for your book. In that case, what he will have to do is that whatever expenses I have incurred, that he will have to pay. Maybe I'm buying all those, like papers, colors and all of that. So for that, he will have to make the payment. Whatever expenses the other person has had to bear, for that he will have to pay. So duty to pay for the expenses incurred. While doing this particular thing, whatever expenses I have incurred with regard to that, the person should make payment. Next is bailor's responsibility to bailee. So what happens is that once all these, like for whatever purpose I had delivered those goods, right? Once that purpose is completed, I have a duty to claim back the goods. That means once I know that this purpose is completed, I should again go and ask for those goods. So this applies when we are giving like a piece of cloth for, like to a tailor for some kind of stitching to be done. You will see they will write, like you should collect your like these dresses and everything within like 1 month. After 1 month, if something happens, we are not responsible. So same thing applies. If we are giving like a piece of fabric to the tailor for some stitching work, it is our duty also that we go there, we claim and we collect that particular goods. Why? Because it will be done within 1 month or within 15 days or whatever time they specify. So from the date when it is supposed to be completed, within 1 month we should come, like collect it from them. After that, if something goes wrong, they are not responsible. So these kind of posters, you would see that we are not responsible if you are not collecting it within 2 months or within 3 months. Why? Because they cannot maintain or they cannot keep all those things with them for a very long time. So they would just make it very clear that within 1 month only you should collect all of this and get this like things done. So same applies here also. So what are my duties? First of all, I will have to tell the other person that like these are the defects that I'm having. Maybe this tempered glass of my phone is broken, so you need to be a little careful while you are using this phone so that you do not suffer any kind of injury or anything like that. I will also need to indemnify the other person in case he has to suffer any kind of loss or something. If he is incurring some kind of other expenses, for that also I need to pay. And also it's my duty to collect that particular goods. If I am giving my phone for, like to get something repaired or something fixed, I should collect it like within a reasonable time. After 1 year, I cannot go and claim that, okay, I gave my phone 1 year back, now you give it to me. So it might not be possible for them to keep it safely for this entire duration. So it is my duty also that I go there, claim and collect my goods within a reasonable time frame only. Also, you will see when we are giving certain things for repairing, right? They will say that if I am saying that, okay, fine, this, like speaker is not working. So what they might say is that, or take for example, I'm giving my laptop for repairing. They might say that, okay, fine, our, like labor charge is like 500 rupees. And also because we need to like buy a new keypad to be fixed in your laptop, we would need extra money for that, like 5,000 rupees to buy that particular thing, or like a certain amount to buy this particular part of your laptop or something like that. Why? Because that is some kind of an extra expense that they had to incur. So for that also I will have to pay them. So these are some of the like duties of Bailor, and again there are some duties of Bailee as well. So first of all, it is duty to take care of the goods. Now, when goods are delivered to the other person, right, the owner is delivering his goods to the other person, Bailee. So Bailee will have a duty that he takes proper care of the goods. Now, what is proper care would depend on the situation, right? Whatever thing is being given or whatever the situation is, it will depend on them what is reasonable care. So they should take as much care as a normal man would do with those kind of things. If someone is giving me just like a piece of cloth for some stitching work, that the care that I need to take would be different. If someone is giving me some like gold coins and gold bars or something like that for making some kind of a jewelry, the duty of care would be different in that case. So what is duty of care would differ from situation to situation. But however a normal man would take care of those goods, same would apply to Bailee also. Bailee should consider that these are my goods only, and accordingly only he should take care of those goods. And if Bailee is, so Bailee when not liable for loss. If take for example, Bailee has taken proper care and everything, even then something goes wrong, in that case the person will not be held liable. So sometimes it might be because of just accident or, like because of misfortune that something might go wrong. So in that case, Bailee will not be liable unless and until he was taking proper care of the goods. Maybe for a person who deals with gold, diamonds or things like that, he can say that, okay, fine, I had these 2 security guards appointed. I have properly, like in the structure also I have ensured that no one can just enter it and then take goods from here. I also have some kind of insurance of this building, insurance of the property or goods or things like that. So if the person is taking proper care, even then something goes wrong, some kind of accident takes place, then he can say that from my end I took proper care, so he will not be held liable in that case. So his duty is that he should take proper care of the goods as much as a person will take care of goods if those, like goods were of his own. So whatever goods are being given in a contract of bailment, we should consider them as our own goods, and accordingly only we should like take care of those goods. Next duty that we have is duty of the bailee to return the goods bailed. So it is bailee's again duty that he should return the goods that are bailed when once the purpose is been completed. So if it was given for some kind of a stitching work, once the purpose is completed, it should be again returned to the original owner. Or if if a certain duration was fixed that for 5 days I'm giving this to you, once that 5 days duration is over, then I should return it. Or once the purpose is completed, then I should return it. Whatever was the whatever were the terms and conditions between the parties. Accordingly only they should act and return the goods that were given to them. And also, if take for example, someone is giving his vehicle or something like that to me for a certain duration, like for 5 days they are giving it to me so that I can use it during this 5 days. After completion of 5 days, ideally I should be returning those goods to the other person. But if I'm not doing it and some kind of damages or losses suffered during that duration, I will be held liable for that. I will need to compensate for all the loss or damage that is suffered by parties. So these are basically the two types of duties that we are having: duties of Bailor and duties of Bailee. So try to remember the parties involved, what is a contract of bailment and things like that. Basically this particular section you can try to remember. Also there are like some questions also that we will see what type of questions are being asked from this particular part. So next is Bailee's right. Okay, so Bailee's right. So there are basically two types of rights that are mentioned: right to lien and right against wrongful deprivation or injury of goods. Injury of goods. So these are the two sections that are being provided. Okay, so first is right to lien. So what is right to lien?
It's right to retain something.
Right to retain something. Yes. So in what kind of cases we will have that particular right?
For example, if that particular bailer he doesn't pay the necessary charges which are entitled to the bailee, then he can have a right to lien.
Yeah. So it is whatever goods were given to us under this contract of bailment, we can retain those goods when until a time we are, like the other person is clearing all the dues and everything. Until that particular point of time, we can retain the goods that were bailed to us. So there are basically two different types: particular lien and general lien. So in case of particular, what happens is that maybe I am, like the other person has given me a piece of cloth for some kind of stitching. What happens is that I am putting in my labor and also skill in that particular task, right? In stitching that particular dress material. In that case, what happens is that I can ask the person to clear the charges, right? I can ask him to pay for whatever amount I would otherwise charge. I would ask him to pay. So until and unless you pay that amount, I will not deliver that particular, like goods or things like that. So it might apply for other cases also, where a person is giving his maybe mobile phone for repairing his speaker or repairing him, like getting his display fixed or something like that. I can say that until and unless you are paying for whatever other parts I bought, whatever expenses I had paid for that, and also for my labor, I'm not going to give you your phone. So you will have to clear all the things that are all the the payment that is due from you. You need to clear that, and then only you can get this particular thing. So next type is general. So in that case, what happens is that certain goods may be retained for some general balance of accounts. Like banks may keep gold as security while giving a loan for the purpose of property or something like that. So in that case, what they are doing is that what I'm doing in particular lien is that the person wanted to get his display fixed, I fixed that. He wanted to get his speaker fixed, I fixed that. Now I'm saying that until and unless you clear the payment, I'm not giving you the phone. So the thing that is involved, right, it is the same only. they gave me the phone, this only I'm retaining. Why? Because they are not clearing the payment with regard to like repairing this particular phone. But in case of general lien, what happens is that it may be some other things also, right? The person is maybe the person wants to take a certain amount of loan, and for that what the bank is doing is that maybe they are taking like papers of some kind of a fixed deposit that he is having, some kind of like digital gold that he owns or something like that. So what they are doing is that they are taking those papers of that fixed deposit or other assets that he is having for some other kind of loan that they are taking. So in particular lien, basically the thing is same. In general lien, it may be for some kind of other like balance of accounts. That bank is giving some amount of loan to the person, so they are retaining some other fixed deposit that the person is having, some other policy that the other person is having. They are keeping those for that particular moment that they can use that in case the person defaults. So this is first one is right to lien. They can retain those goods for a certain duration until and unless the payment is clear from the other person's end. Also next is right against wrongful deprivation of or injury to goods. So these are two sections, like from first we have sections for bailment, then pledge, and then again we have two different sections for bailment. So these are the two different sections. Now what happens is that in case of bailment, right, if you are giving your laptop to me, I need to take care of that laptop as if it's my own. I will have to get it fixed, or for whatever purpose you are giving it to me, I will have to get it done, right? So what happens is when you are giving your laptop to me, it's almost like I am the owner of that laptop, because I am taking care of the laptop like an owner only, right? So I have same kind of like responsibilities that I need to take, like take care of that laptop, or like protect it from other third parties or things like that. So this is the other right that we have. Because of that reason only we have this other right, that right against wrongful deprivation or injury to the goods. Basically what I can do is that I can file a case also against some wrongdoer, right, against any other third party who wrongfully maybe tries to obtain possession of those goods, or wrongfully wants to take those goods away from me. In that case I have same kind of rights like the real owner to file a case against that particular third party, and then like get the goods back. So if take for example someone is giving their mobile phone to me to repair their speaker or something like that, what I have is that if someone else tries to like wrongfully take possession of this particular mobile phone, I can file a case against that particular person also to get possession of this particular mobile phone. So basically against third parties I also have a right to protect the goods that I am being like that the other parties have paid to me. So basically I have a right that I can file a case against third parties to protect it from any kind of, protect myself from any kind of wrongful deprivation from the goods. And also if like in that particular case some compensation and all also I would be entitled to. So accordingly basically I will have the same kind of rights only like the real owner will have. So I can retain those goods until and unless all the payments and everything is clear. And also I have this right against wrongful deprivation or injury to goods. If someone is trying to cause like loss to that particular goods, trying to destroy or diminish its utility or value or something like that, I have a right that I can file a case against that particular person to save the goods that were bailed to me. So these are basically the rights that we are having. So this is for like bailment, okay? Like whatever is important is with regard to rights, duties, and the basic like definition only. What is bailment? Who are the parties involved? So what is bailment? We are giving some goods, we are delivering some goods for some specific purpose to be done. It may be to get that repaired, it may be to get a servicing done for washing a car or something like that. Now another type, under bailment only, there is another type where we are giving goods. But what is that? It is pledge. So what is the difference between bailment and pledge? Anyone? Because pledge is also one of the types of bailment only. So what is the difference, main difference? Anyone? Neha?
Yeah, ma'am, in bailment, when the goods are bailed, it can be like for any purpose. The goods specially don't act as a security, but in pledge, whenever the goods are bailed, that particular good is acting as a security, and it is for obtaining a particular loan amount.
Yeah, so that is the main difference, that in case of bailment, it is for performance of something. Maybe I am using this phone to get it fixed, to get it repaired, or maybe I am using someone's car to wash it, clean it, or do anything that they want. Maybe I'm taking like a gold coin to make some kind of a gold ring or jewelry out of this, or something like that. So basically, in case of bailment, I'm using those goods to do something with those goods or to make something out of those goods, right? Taking a gold coin and making a gold ring or something like that. So in bailment, those goods are given to us. Why? Because those goods are very important. We are using those goods to like complete this entire contract thing, right? Entire bailment thing done. But in case of pledge, what happens is that bailment of goods are done as a security for payment of a debt or performance of promise, right? So someone, I can give some goods to a person so that he gives me some amount of loan, or so that he like perform some kind of a thing, right? Basically it's with regard to loans only, that I'm taking a loan and I will like give a certain thing. So this was applicable mostly when, like, like in case we are going to banks and asking for loans, they would obviously take like our property papers or something like that, right? But in case I want to take some kind of an amount from my relatives or my friends, what I can do is that what I can do in that case is that I can just tell them that, okay, fine, you keep my ring or you keep my phone or something like that, right? And what happens is that you keep that as a security and I will for sure return you the amount within like 1 month or 2 months, and then I will again collect that particular ring or collect my phone or something like that. So in case of pledge, what happens, it acts more like a security with regard to payment of a debt that the person is giving to us. It may be for performance of a promise also. So any example that you can think of with regard to performance of promise? So if you have visited this Bangalore Palace, right, there you will see in entrance, they will give you like some audio recording is there, so that you can just, like for this entire Bangalore Palace, they would explain what is what, how it was done, what everything will be explained, right? Basically like an audio guide it would act. So they will give you like a headphone and something like a phone only, right, where that recording would be stored. So now they do not know whether you will be returning those headphones before leaving the place or not. They are giving those headphones to you. It might be like 2,000, 3,000 rupees worth, right? So what they will do is that they will take your like some kind of your government ID card, right? Maybe your Aadhaar card, passport, or driving license or something like that. Or if you do not have an ID card, you can even pay them 2,000 rupees. So obviously you would not buy those headphones, right, for 2,000 rupees. So obviously to get your money back, you will go there and you will collect your headphones. So that is what, that is performance of a promise. You are supposed to return those headphones after you are done visiting this entire palace. You are supposed to return that, but there is no surety whether you would return those headphones or not. So what they are doing is that they are taking some kind of a security or like an assurance that obviously you would need your driving license, obviously you would need your passport, and you will come back to collect that. So you will return those headphones. So same would apply there also, that with regard to pledge. So this was more applicable when, you know, like in earlier times, people would take loans, right? That I need like 5,000 rupees loan. You just keep this gold ring and gold necklace or something like that. I will collect it later on. So like that only it will also work. So pledge is sections 172 to 179. So for pledge, what is essential? That delivery of goods or title. I'm giving those, you know, like some kind of goods, or maybe I'm giving documents with regard to that as a security, so that the other party is willingly giving me that particular loan. And purpose of pledge is always for security. We do not want the other party to do anything with regard to those, you know, like those goods. It is basically as a security only. So there are again two parties involved in pledge, pawner and pawnee. So whoever is giving it, that would be pawner, and the other person would be pawnee. So again, they have certain rights and duties. Okay, so this is also more or less similar to bailment only. Just the difference is that we are giving it as a security. In case of bailment, those goods are needed to like perform this contract of bailment that the parties have entered. So first right that we have is right to retain the goods that were pledged by the person. So right to retain the goods that were pledged by the person. So same again here also it will apply unless and until the other party is clearing the loan, right? Whatever amount he had taken, unless and until he is repaying that particular amount, this other person can retain those goods, retain the assurance that has been given. So if someone is giving like a gold ring to be kept, he can say that you clear that particular debt, and until and unless you clear it, I have a right to retain this particular goods as a security. So first is with regard to retention of the goods. Secondly, right to recover extraordinary expenses incurred by the pawnee. So while keeping those goods, right, whatever goods were given to him, while keeping those goods, if the other person had to incur any kind of expenses to maintain or to keep those goods, that also they can claim from the other person. Like any example that you can take, maybe I'm giving some goods to the other person as an assurance, and what he had to do is that just to maintain it, just to keep it safe, he had to get some servicing done maybe, or get something fixed or something like that. So in that case also he can say that it was like an extraordinary expense. I was not knowing that I will have to get a servicing done or something like that to maintain this particular goods. So I will also recover, you know, like I'm also entitled to that particular expense which I have incurred. So next is obviously those goods are given as a surety only, right? That I'm going to repay my loan. So in case the other party defaults, then what happens is that I have a right to maybe sell those goods also. I will wait for a reasonable time. Maybe the person said that you keep my gold ring and you give me 5,000 rupees. I will repay that within 3 months time. So I waited for this 3 months time. I informed the person also. I sent him a notice also that 3 months is already over. You should return the payment, or otherwise I will sell it or something like that. Even after that, if he is not returning, then I have a right that I can either keep that gold ring, I can start using it or things like that, or maybe I will sell that gold ring and I will try to get an amount out of it. So if I gave 5,000 rupees loan to the other person, and by selling that gold ring I just got 4,000 rupees, in that case what happens is that I'm still entitled to 1,000 rupees from the other person. So other person is still bound to pay me 1,000 rupees. And if I'm getting like 6,000 rupees by selling that gold ring, I'm supposed to return this extra 1,000 rupees to the other person. So basically, whatever goods are being given to me, that was given as a surety. So I have a right that I can even sell those goods to get that, recover that particular amount, or I can even start using that particular, those goods that that were given to me as a surety. I will just retain those goods and I will start using those goods. So in case of bailment, someone is giving their goods to get some kind of a work done on those goods. In case of pledge, what they are doing, they are delivering some goods, but by as a surety only, that for sure I will be returning this particular amount that you have given to me, and as an assurance you can take this particular amount. Now, what is the difference between pledge and mortgage then? Because in mortgage also we are, like giving a surety only, right? With regard to some things that, okay, fine, if I am not able to repay the loan, you still have this particular thing that I own. So what is the difference between pledge and mortgage?
Ma'am, pledge deals with movable property, whereas mortgage is immovable.
Yeah, pledge is with regard to movable properties. Mortgage is immovable properties, right? So in case of mortgage, I may say that I am, like you keep my property papers, and if I am not able to repay this particular loan, you can, like you will have rights over that particular property, or you can sell that particular property or things like that. So it is basically with regard to immovable property. But in case of pledge, I may give anything, right? It may be my phone, watch, or any, like the simple thing also. It may be some kind of a movable property that I'm giving. So this is applicable mostly for like small loans that like people would take maybe from relatives or things like that. Even there are cases where government has mortgaged some like gold to obtain loan. It was, I think, like some 1991, I guess, government mortgaged some like gold to obtain loans from this Bank of England, and from Japan also they obtain a, like big amount of loan. So with regard to that also, it may be obtained that some kind of movable properties, they may like pledge, and then they can obtain a loan, and they can fix a time also that within this particular time we will repay the loan, and again we will collect the goods that we have pledged. So accordingly it can be done. So now next topic that we have is with regard to agency. So for pledge also, you can try to remember the section that defines the specific type of contract and things like that. Okay, so next type of specific contract that we have is agency. It is the last chapter, chapter 10 of the Indian Contract Act. Now agency is like very common, right? Especially nowadays when like there are so many companies, so many people are doing so many work. So obviously one person cannot do all the work, right? If someone is opening like a startup, someone is opening some kind of a firm, someone is opening some kind of a company, obviously he cannot do all of the tasks himself. So what he will have to do is that he will try to appoint some other subordinate persons who can help him in performance of his work. So in those kind of things also, we can say that there can be like like principal and agent kind of a relationship, where there will be a principal who will take the major decisions, who would say that this is how the thing should be done, or maybe this is what we want to achieve, and now you do your own work. So in case of agency, what happens, there will be a principal and there will be agents who would perform certain tasks on behalf of the principal. So it is chapter 10 of the Indian Contract Act that relates to agency. Now it is section 182. Okay, try to remember the section 182 that defines both agent and principal. So who is an agent? Agent is a person employed to do any act for the other and to represent another in dealing with third persons. So agent may be appointed in order to perform his own tasks also, or to represent this person also. So one good example would be this LIC only, right? They are having so many agents who would go to people and try to convince them to buy their policies. So in this case, LIC would be like the principal who is like giving directions to the agents that these are the different policies, and you try to gather customers who would be interested to buy all of these policies. This can be also applicable for all these companies, right? Like your Oriflame is there and one more is there, right? So again, there are many other companies also who are maybe selling health supplements. So what they will do is that they will hire some agents and they will say that locally you go to people, you approach them and you try to sell all of these products that we are having. So in that case, what agent is doing? Agent is trying to perform some of the tasks on behalf of the principal that they are having. So agent is the person who is employed to maybe perform something on behalf of the other, or to represent the other in dealing with other third parties. Like if there is a company who wants to maybe like sell some kind of health supplements, the agents would go to people and would represent the company, right? Would represent their principal that, like we are so and so company, we are having all these health supplements and these are of a certain this kind of a quality, you can use them, you can buy them. In that case, what agent is doing, it is trying to represent the principal or that particular company in front of other third persons and get the work done accordingly. And who is principal? Again, it's defined under section 182 only. Try to remember the section. Who is a principal? The person for whom such act is done or who is so represented is called the principal. So the person who has delegated his authority would be the principal. So if LIC is employing a lot many people as their agents, LIC will be what? LIC will be the principal. So LIC will give directions to their principals. Maybe LIC would say that for this particular year, we have a target to get like 100 customers for this particular policy. So the agents would do accordingly, right? So accordingly, it will be done by the agent. So who is an agent, who is a principal is defined under section 182. But now who can be appointed as an agent? So it is 183 that mentions. So any person who has attained the age of majority, is of sound mind, can be appointed as an agent. So when a person enters into like an agency relationship, obviously it's like a contract only, right? He will have some kind of contractual obligations. If he is saying that, okay, fine, I'm going to find customers for LIC, what he is doing, he is entering into some kind of contractual obligation. So it's very important that the person also knows to what he has given consent, what are the consequences or things like that. So again, same rule applies, that the person should be major of sound mind or other things that may be there. So that kind of a person may be appointed as an agent. So same, whatever qualification we studied for contract, same applies. Same applies here also with regard to agency. So a person who is of sound mind, of the age of majority, they can appoint an agent because they would, like they will be liable and to their, like agents. If agents are doing something, the principal would be liable, right? So they should also be capable of entering into a contract. Otherwise, they would say that I'm a minor, this contract itself is not valid, so the person is not my agent only. So like that should not happen. So who may be an agent? Again, same thing again applies, because the agent would also have some kind of obligations, some kind of contractual relations. So he also should be a major person, and he also should be of sound mind, so that he understands his obligations and accordingly he can perform those obligations. Now, authority of the authority of an agent. So how authority can be given? It may be express also, it may be implied also. It's section 187. What is express authority? When it is expressed by words spoken or written. Maybe LIC is saying that, okay, fine, being an agent, this is what you need to do. This is how you need to approach your customers. This is what you need to tell them. So everything is in a proper written format. Everything, you know, like for every single thing, directions are given that these are the people, these are the, you know, like the targeted group to whom you need to approach. This is what you need to tell them. This is how you need to convince. This is what you need to try to sell to them. So in that case, what happens? It will be express authority. Expressly, they are saying that this is how it should be done. This is what you should do. But it may be implied also, where it can be inferred from the circumstances that may be present, or that may be inferred from the situation which is there. So LIC might say that, okay, fine, for this particular year, we want like 100, you know, like policy holders for this certain policy. Now, how the agent would get 100 customers, that entirely depends on the agent. Might be LIC would say that in this particular year, we want to achieve this much amount of profit. Now, to achieve that much amount of profit, whatever the agent has to do, it is what? It is implied authority that is given, that you need to go to people, you need to approach them, you need to get customers to our company. So that will be what? That will be an implied authority. Directly LIC is not saying that this is the targeted group to whom you need to go, whom you need to approach, or things like that. But again, it is implied from the situations that are present. If they are saying that this much amount of profit we want to generate, that it's implied that we need to get this many amount of, you know, like these many number of people or something like that. So it may be expressed also, or it may be implied also, how authority can be given to the agents. So there was one case also where what happened is that there were like agents of LIC. Okay, so what agents will do basically, they will you know, like go to people, they will you know, like convince them to buy policies. After that, they only will collect money from them, and they only will go and deposit it in that LIC office, right? Like customers will not go directly, but agents only would do that on behalf of the customers. So same thing happened in that case also. It was like chairman LIC versus Rajiv Kumar Vaskar. So what happened in that case is that this agent was like taking money from that particular customer, right? He was taking money and he was convincing the customer that I'm depositing it in that LIC office only, but he was not depositing it. So obviously there is a time given, right? That if you default for like 3 months, that policy would lapse or things like that. So accordingly, this policy also lapsed because the payment was not deposited for a certain duration of time, and the agent was taking money from the customer. So later on, this you know, like the agent died, and the person came to know that like agent died. Then when the person approached LIC office to deposit that particular premium, then he came to know that this agent was not depositing the money for, you know, like all these months. So later on, he filed a case against LIC. So in this case also, it was held that LIC is like a principal and whoever are their agents, right? So there is like a principal and agent relationship, and LIC will be liable for any kind of like default or any kind of fraud or anything that their agents are doing, because there is like a agency and principal relationship. So this you know, like the for the fault of agent, principal was held liable. So that LIC case is very, you know, like LIC thing is very good example for this agency agency part, because there they are giving their, you know, like appointing agents and giving them tasks and all of that. Next thing is termination of agency. Okay, so termination of agency. So once this agency contract is entered between parties, right, how we can terminate that particular agency? It may be done when the principal, right, whoever is appointing that principal, if he wants to terminate it, he can do it. If LIC is appointing some agents to get some works done, LIC may terminate. LIC may say that, okay, for this particular agent, he is not able to get any customers to them, he is not able to achieve his targets or things like that. They might say that, okay, fine, we are terminating this particular principal agent contract that we are having in between us, we are terminating it. So accordingly, because the principal is terminating it, it may come to an end. The agent may also put an end to this particular contract. Agent may go to the principal, the LIC office, and say that I do not want to continue being an agent, so I want to put an end to this particular contract. Accordingly, also it can be done. Also, when business of the agency is complete, if I'm appointing an agent for a certain specific purpose only, if I'm saying that for this particular year, I want to get these many customers, so your task is only for this 1 year only. During this 1 year, you should try to get as many customers as you can. So after this 1 year time frame is over, the agency contract would also get terminated. Why? Because it was for a fixed duration only, for a specified purpose only. So what was the purpose? That within 1 year you should try to achieve these many number of customers. Or I can just say that your target is to achieve 1,000 customers. Once this 1,000 customers are achieved, this like contract would also terminate. So once the work is done, it can be terminated. It can be when either party dies or becomes incapable of contracting because of unsoundness of mind, then also it will get terminated. And when principal is adjudicated as an insolvent, if there is a case filed against the principal and he with regard to insolvency and bankruptcy, and in that particular case he was declared as an insolvent, in that particular case also it would terminate, because principal is no more in a position to pay the agent for all the work that he will be doing. So is this part clear regarding agency? So again, there are certain duties, okay, with regard to principal also, with regard to agent also. So for principal, what we are having duties are conduct the business of principal according to the directions given. If LIC is giving certain directions to their agents, agents should do it accordingly only. It is his duty. If LIC is saying that, like you should disclose only this much of information to the customers, they should do that only. They should not disclose some other, like personal information of LIC to their customers. So whatever directions are being given to the agent, those guidelines or those directions they should follow while performing their task. And if while performing this task any kind of skill is needed, I should use all those skills and accordingly only do. If someone is appointing me as their agent to draft some kind of a contract on their behalf, what I should do is that whatever legal knowledge I have with regard to drafting of a contract, I should use that. I should not be like, okay, fine, I'm anyways drafting this contract for someone else, not for me. So why should I include all the important clauses under the contract? So I should not do that, because that will expose that other person to any kind of, legal harm or legal consequences, right? So whatever important terms or clauses are there, I should insert all those important clauses in the contract. So whatever skill is needed to perform this task, I should use all those skills and I should perform it accordingly only. And also, if take for example, I'm an agent of LIC, I'm getting some customers, I'm getting money from those customers, I'm buying policies or things like that, I should maintain a proper record of that, right? I should have proper accounts of that. Okay, fine, for this particular month I sold these many policies, I earned this much of money, or these many people came, this much of money I earned. So accordingly I should maintain an accounts of that, And if the principal is asking for those accounts, I should also, you know, like show those accounts to the principal as well. So if there are like any difficulties or any problems that I'm facing while performing my task, I should inform with regard to that also to the principal. It is also my duty because I'm performing someone else's task. So if I'm not fulfilling the directions given by the principal, I'm just violating the directions given by the principal, then principal can say that we do not want to continue with this contract because maybe you are disclosing some personal information of LIC to the probable customers. So we are not continuing with this particular contract with you. So that also, so I also have a duty that whatever is directions are being given, that I am fulfilling, otherwise the contract may get terminated. So if, you know, like while entering into this contract of agency with LIC, right, my main purpose was to approach people and sell policies of LIC. If I am trying to sell them some kind of like my own policies or policies of some other company or things like that, and I'm earning profit, LIC can also claim profits from that. Why? Because in name of LIC, I'm trying to earn profit from other customers. So with regard to that also, like it is also my duty that I should fulfill all of that. So those were like duties of agent. What kind of duties agent is having with regard to towards the principal, and there are certain duties that principal will also have towards his agent. So if agent is suffering any kind of loss or any kind of harm, with regard to that, principal should indemnify him. If agent is doing something in good faith and you know, like he ends up causing some kind of loss to a third party, in that case also principal should only indemnify to that other third party also and to the agent also. So same applies to that case also, where the agent was not depositing the, you know, like the policy premium, monthly premium to LIC office, but he was using those money for his own self. So in that case also, principal was held liable, right? LIC was held liable to compensate the customer. So, but for legal acts only, the agent will be indemnified. I cannot do some kind of an illegal act and then I cannot ask that you should, you know, like indemnify me for this particular loss that I have suffered. Why? Because it was some kind of a criminal act that the person was doing. And if because of my like lack of skill, my negligence or things like that, the agent is suffering loss, for that also I should compensate. That is also my duty only, because it was also for me only that the other person had to suffer some kind of loss or damages. So there are some rights also. Again, these rights are also rights of an agent. So what are these rights? First is right of retainer. So these rights are again more or less similar to bailment and pledge that we have already studied. So same applies here also, right of retainer. That agent can retain any kind of amount that he has earned or any kind of, you know, like retain certain things for, if the principal is not clearing certain amount, if the principal is not giving him commission or his salary or his remuneration, he can retain those particular, you know, like goods or profit. So it is right of retainer. Next is right to remuneration. So an agent, when he has wholly carried out the business of the agency, has the right to get remuneration of any expenses suffered by him. So if he is suffering any kind of loss or anything, for that also he needs to be paid for the work that he has done. If commission is fixed, if salary is fixed, whatever it is, that should be paid. Unless and until it is clear, he will have a right of retainer as well. Right of lien on principal's property. So he can hold certain movable, immovable properties. It may be some files or important documents of the principal that he is keeping with him until and unless the remuneration is clear. He has right to be indemnified also while he is doing lawful acts and acts assigned to him by the principal, and during that case, if he suffers any kind of loss, for that he has a right to be indemnified. Right to compensate, an agent has a right to be compensated for any kind of injury or loss that is suffered by him because of lack of skill or competency of the principal or because of principal's negligence. So with regard to that, if he is suffering any kind of loss, for that he should be compensated. While doing any lawful act, if he is suffering any loss, for that he should be indemnified. He has a right of lien with regard to movable and immovable properties of the principal in cases dues are not cleared by the other person. He has a right to remuneration from the other person. He has right of retainer as well. So these are some of the rights that the agent will have. Okay, so here are some questions that you can try to solve. So these are also relating to like general parts also and the specific contract part also. So what will be the first question answer? Contract to perform promise.
Contract of guarantee, ma'am.
It is a contract of guarantee. So which section is relating to contract of guarantee, like defines guarantee? And also the parties involved. It is 126. Next is section 128 of the Indian Contract Act provides for it is talking about surety's liability. So what is surety's liability? It is coextensive. If like the person is if the principal debtor has taken 5,000 loan, then and on a certain interest, then surety's liability would also extend to that interest as well. So it is coextensive. If the principal debtor is liable for the principal amount plus interest, surety would also be liable for the same thing only. So it is section 128 that talks about surety's liability and it is coextensive. Next one.
Continuing guarantee, ma'am.
Yes, a guarantee that continues for a series of transactions is known as continuing guarantee. Try to remember the section 129 for this particular. Death of surety operates as it is section 131. So death of revocation of continuing guarantee by surety's death. So in case of surety's death, in general normal situations, it would work as a revocation unless and until the contract specifies that it will continue or something like that.
It may be revoked anytime.
Anytime. Yeah, so for further transactions which has not taken place, it can be revoked by them. And how it can be revoked? By giving a notice to the creditor. So if it is continuing guarantee, before that, for the next coming transactions, they can say that I'm no more giving guarantee with regard to this thing.
Surety.
In case of, yeah, contract of guarantee, the person who gives guarantee is surety, and it is 126 only that defines surety also.
Creditor, ma'am.
Which section? Same only, 126 only defines also, and the parties involved also. All are 126 only.
Principal debtor.
This, yeah, principal.
Pledge.
The performance of a promise is called pledge. Which section? 172, pledge also, and parties involved also.
Bailment.
Yeah, section is 148, bailment, and also parties involved in bailment.
B's property.
Yeah, B's property. This applies for minor also and for juridic person also.
Quasi-contract.
The elements of contract might not be there, but still on equitable grounds, court might say that parties are liable.
All of the above, ma'am.
Yeah, right. All of the above. So all the rights he is having, he can file a case also, he can retain the goods also, and after giving notice, he can sell the goods also.
To whom the goods are delivered. A.
But section is again 148 only.
Who delivers the goods.
Goods 148.
Ma'am, he in the sense over here, the pawnee, right?
If
In the question.
Yeah. One.
He has a right to sell the goods pledged after giving a reasonable notice of sale.
After giving a reasonable notice of sale. It is 1. So it is section 176 where pawn is right. If the pawner defaults, then he can give a reasonable notice and then he can.
All of the above, ma'am.
This also all of the above. So it is section 125, rights of indemnity holder if a case is filed.
Bailee's particularly.
Particular 170.
Seema.
Employ an agent, yeah, any person who is of the age of majority according to the law to which is subject to and is of sound mind. So it is section 183, who may employ an agent. One 182 is what is the first one only, agent and principal defined. So sometimes see what happens, right, in question paper, right, there may be 2-3 questions where in one of the question only they are, like trying to give you a hint. Maybe take for example this, right? Take for example, for this particular question, they also mentioned the section, who may employ an agent as per the provision of section 183. So in that case, you can just guess, right, that okay, fine, if 183 is mentioning who can employ an agent, before that we should at least know who is an agent, right? So it may be just the section that comes, like before 183. So it will be like the 182 only. So like that also sometimes you can guess that okay, fine, if 183 is mentioning who can employ an agent, it might be 182 that talks about agent and principal, like it provides further definition. So like that also sometimes you can guess. And also for the name of parties, right, that is one very common question, so that part you can try to remember. Next is
Both A and B.
agent's authority, both A and B. It can be implied also, and it may be implied from the situation or the circumstances that may be present. See, for many things, right, like sections based questions are asked for contracts, and more so for like specific relief act, only sections only they are asking mostly. So at least try to remember for specific types of contracts, parties involved, and also like which section defines that particular contract, and also for like rights and liabilities also, right? How many ever sections you can remember, try to remember that part. And also like for other things, normal questions also ask, right, a guarantee which extends to a series of transaction is what kind of a guarantee? It's a continuing guarantee. So these kind of questions are also being asked. Okay, so this was all about contract. So any part that you have doubts or anything for contract? And also like the definition part, right? Section 2, that part is also important. Which section defines this particular word and all of that. That is also very important. So that part you can try to see. Okay, fine then. So Indian Contract Act is over. So we can continue with the remaining subjects like Specific Relief Act and Negotiable Instruments Act if you don't have any doubts from this part. So fine, then I will share this document with you. You can go through the provisions and also you can try to practice these questions also so that you have an idea on what kind of questions may be asked for this particular part. So fine, then we will continue with Specific Relief Act in next class, okay?
Thank you, ma'am.
Yeah, okay, thank you.
Good night, ma'am.
Good night.